¿Aló? Bueno, sí, buenas tardes. Vamos a dar comienzo.
Well, good afternoon. We will initiate the last panel over the protection of brands in the evolving environment of social media. I hope you enjoy it. Maritza, whenever you want. Well, we will have first a video, and afterwards you may start. Brand protection in the evolving environment of social media. We have Daniel Legaspi from Santamarina, Steta, SC, Mexico. Megan Carpenter, University of New Hampshire, Franklin Pierce School of Law, United States. The moderator, Maritza Reátegui, from Rodrigo, Elias, and Medrano, Abogados, Peru. Good afternoon to all of you. We're in the last panel of the day. We have luxury speakers, and we will be touching a topic that is not only seen from the professional point of view, but also from a personal perspective, because the topic of social media keeps growing, as well as the users. Therefore, we will begin with our first speaker, and I will briefly read her CV. Megan Carpenter is the Dean of the Faculty of Law from Franklin Pierce, one of the 10 best faculties in topics of intellectual property for more than 3 decades. Megan is a recognized leader in topics of intellectual property, technology, and education. Her history includes amazing achievements in the development of new sources of income, product innovation and services, as well as creation of programs, policies, and a topic that I love, which is a topic of diversity and inclusion. Megan is the author of different articles in the topics of intellectual property and innovation, including the book of Evolving Economies. She has published in books and Rights and Laws magazines. She's an author and frequent speaker in many means of communication, including the New York Times, amongst others. Megan started her practice in laws in Elegate before she went into the academy. Megan, please go ahead.
Gracias, Maritza.
Thank you, Maritza.
Me here today. I'm going to talk a little bit about brand protection in the evolving social media environment. We have a few, I'm going to kind of do an overview. I don't think this is working. There we go. So here's an overview of what I'm going to talk about today. We're going to talk about Generation Z and consumer decision making, because one of the things that's really unique is, especially with Generation Z, having increasing buying power and being kind of the largest group on social media with the most layers of social media presence. It's good to sort of know the audience that we're talking about here. And then I also want to talk about challenges and opportunities that this presents. Whether it's increased consumer engagement or thinking about a legal framework that might be a little outdated for a social media environment. We'll talk some about the opportunities that are presented online, and then also some with counterfeiting. And then I'm going to segue into talking about practical strategies and some toolkits for you and for your clients as we go forward. Oh, there we go. Hold on. Now I have to go back. Okay. So Generation Z is motivated by qualities like authenticity and morality and engagement. This is not. They have a strong sense of self, and in fact, 92% of people surveyed said that it's important to stay true to who they are as a person. They also maintain a strong sense of morality. 89% say that they determine their own moral code. That morality is somewhat situational, though. So brands serve, according to members of this generation, as kind of an extension or a reflection of their own identity. 80% of respondents say that it's important that brands fit their style on a kind of an individual basis, that it reflects really who they are as a person. They also apply situational morality. So 48%, and this is interesting because we were talking about the authenticity piece, but we're also talking about kind of how they make purchasing decisions. And so 48% say that it's not okay to buy counterfeit products, that authenticity itself is very important. But when it comes right down to it, income is slightly higher than morals. So 47 to 37% as a basis of consumer purchasing decisions. All of that kind of provides a background for us to think about how we might operate both brand protection and developing strong brands in the online social media space. And I always like to think about brands themselves as, in a way, a storage container for information. A brand doesn't, a trademark doesn't just designate a source of goods and services. We say that in trademark law, but what it does is to really tell you more than you would ever imagine. If you think about your favorite fast food restaurant, you can probably list many things on the menu. You could probably tell us, what their packaging looks like, maybe even how clean their bathrooms are, or how not clean their bathrooms are, or what the floor looks like, what the furniture looks like. It's really the whole embodiment of a particular product or a particular service. If we think about Corona, which I think is the third most popular brand in Latin America, down 2 notches recently, you could think about the taste. Is it crisp? The smell of it, is it so distinctive? The particular unique bottle, when it's refreshed, is it really good for a summer day? Not too expensive, really good for sharing, okay for day drinking probably. All of these things when you that a brand can symbolize to the consumers themselves. So when I think about the kind of suitcase, the kind of storage container that we have for brands, it's not just a limited space, but it's like a magical suitcase that you can take so many things out of. And that is what we're dealing with here. So let's turn to some of the challenges that this presents in the world of social media. First, we have increased consumer engagement in social media in ways that we have not really experienced with brands before. When I first started practicing, we really felt like for our clients wanted to control the meaning of that brand and whatever went in that suitcase. Stuff that got packed in the suitcase, in that storage container, is only what the brand owner put into it. And they felt very strongly about that. But in an era of social media, the suitcase is more like a broken suitcase that is bursting at the seams, where all kinds of things that consumers might do with a brand online also end up being part of what that brand will symbolize. And so that presents an enormous challenge for brand owners in a way that we just haven't seen before. Trademarks are really also part of our everyday lexicon, our everyday dictionary. We're seeing increasing use of trademarks as kind of cultural commentary, as art, or as aesthetic objects, which can make brand owners increasingly uneasy, and we need to be thinking about that. Uses like this, consumers feel like they can do whatever they want to comment and use trademarks in order to do that. This also extends to other brands, not just to consumers. So brands themselves, a second brand, might end up establishing a particular product or a particular service in order to themselves comment on a senior or dominant brand as part of their own marketing or their own business model. And we saw that certainly with this outdoor brand called South Butt. You see all kinds of things being done with brands that would be thought of as disparaging perhaps in the past, or thought of in some way as at least dilutive of a particular trademark, that are sort of part of our overall lexicon on a daily basis. So this is something pretty absurd, but a social media artist who has makes a practice, the entire business is tattooing brands on pigs, live pigs, and sells these pigs for over $70,000 each. So this is kind of an absurd example, but what we're seeing are just these, all of these examples show that we're seeing brands challenged now, that would have felt in the past that the strong protection was really necessary. But in this social media environment, that kind of approach, the strong-handed approach where you control everything that goes into that suitcase, can certainly backfire. So that brings us to challenge number 2, which is around user-generated content. And we all know that influencers can be a way to build brands themselves, but infringement is also a way to build influencers. So let's look at a few different examples. Influencers are a significant part of brand protection and brand development on social media. And becoming sort of an influencer is part of, is so many, there are so many people involved at all levels, including, the youngest ages. I thought this clip was a little funny because they're talking about, with jobs you need to have training, and then you have to physically go do the job. How about being an influencer instead? So the world of social media is rife with people who are influencers, but also people who want to be influencers. And one of the challenges that brands are facing right now is that there are people who are actually not being paid by the brand, that are not sponsored by the brand or not affiliated with that brand, who are pretending to be so that they build enough of a following so then they become an influencer. Now, does that support the brand development? Is that something that would fit inside a suitcase? Or is that something that would be typically thought of in the likelihood of confusion context as a problem for clients? So these challenges sometimes lead to opportunities online and with social media. So brands themselves have developed the engagement of user-generated content in order to invite consumers into that space, to invite them into the storage container. So one example, I think, Nike would be a great example of people kind of designing their own athletic gear and tennis shoes. Also, M&Ms have been doing that, and there are many, consumers who can design their own M&Ms for whatever, special occasion that somebody might have. There also is an element of PR that is then something that brands need to consider in the enforcement and the cease and desist space. We talked about how kind of in the past we might have approached things as, with a likelihood of confusion, thinking about the affiliation and the sponsorship and trying to control that brand image, but the introduction of consumers, does not only presents a challenge, but then how does one actually enforce in a way that doesn't backfire with public relations? So Starbucks has done it great ways and has done it in really poor ways. And I think originally Starbucks really took that kind of aggressive approach with imitators who might have used different blends and different trademarks belonging to Starbucks. But then they sort of realized that perhaps to allow some of this to exist would itself be a brand enforcement and development strategy for them. So when someone set up a dumb Starbucks coffee shop, they let it go and they got involved and sort of helped promote that. And in doing that is so counterintuitive to historically how we would have approached trademark law, but it was an actual sort of, it was an excellent brand development strategy and an enforcement strategy because it also helps to then educate consumers. Old Ox is a small brewery that produced beer, and rather than going after when Red Bull and Old Ox resolved this amicably, what we saw was a huge boost in sales for Old Ox. So you can see these things actually working out in a business sense, but wouldn't follow the kind of legal framework that we always would have used in the past. The best C&D ever that many of you probably have seen or heard of is from Netflix, and there was an unauthorized bar that was adapting kind of a theme of Stranger Things, which is as a popular TV show produced by Netflix. And so their cease and desist letter, realizing that this would be a good way to respond to the interests of that generation, especially Generation Z, got a lot of great press, a lot of great publicity, and no harm done when they did issue the C&D, but they did it in a way that was clever and cheeky and ended up going viral. And the kind of added, what you'll hear from Netflix attorneys is that, the added benefit here was that by approaching it in the way that they did, they ended up educating consumers about the legal issues in a way that they never could have had that reach otherwise, so in a really kind of unconventional way. And you can find it online if you like. So this brings us to kind of the final component of challenges and opportunities that we see online and with social media. And I just wanted to mention counterfeit goods because that is especially in the context of the pandemic where we...
En el contexto de la pandemia, hemos visto un crecimiento increíble de productos falsificados vendidos en línea, en paralelo con la explosión increíble de las compras en línea. Y lo que hemos visto en 2 años de pandemia fue casi 220 billones de dólares en comercio en línea. Eso fue solamente 2020 y 2021. Y los gastos o compras en línea llegaron a 28.7 trillones. Una compañía que a la misma vez, mientras había una explosión en productos falsificados, o sea, en salud y incluso tapabocas, fue un reto para los dueños de marcas.
And I'll just mention this briefly because we've touched on it kind of throughout the last few minutes, which is when we think about the legal principles that we have surrounding trademarks and branding and advertising law, so much of that is focused on an analog world. So when we think about likelihood of confusion, for example, we talk about infringement relating to confusion with affiliation or sponsorship or some kind of association or connection. But when we have this kind of overall suitcase of information that is the goodwill associated with a brand, and that we are now inviting consumers into that, whether we like it or not, they've sort of made their way in to help sort of shape the perception of that brand, then some of these principles will no longer apply in the practical ways that we want them to. And one of the things that you always want to think about is aside from trademark laws, just to always be careful to abide by advertising laws, depending upon what country, what region, what jurisdiction you're in. There are all kinds of problems that celebrities have had on social media with some of those examples, whether it's P. Diddy or Kim Kardashian, the list could go on and on. I'm gonna sort of jump through this, but in the US, it's also really important to think about FTC guidelines. So now I want to get to the practical part, because what I want to leave you with are some practical tips and strategies and solutions as you think about how to proceed in this kind of new world that is constantly changing and evolving. And I'm going to cover 3 different areas that are going to be in your toolkit. One is IP, and another is architecture, technology solutions, and then a third I'm going to call collaboration. And feel free to push back on these or add your own in. I'd love to hear from you as to what tools you use in your toolkit. So when it comes to IP, certainly one of the things that I hope that you can take away from some of the discussion today is one of the best ways to talk about online enforcement and protection of brands is really to have a strong brand itself, to be proactive in that space. Also, you want to think about, not just a word or design, but think about how you might incorporate trade dress. Non-traditional marks are burgeoning in this space. Plan ahead, invest in clearance and make sure that your clients understand the importance of doing that at the front end. Also, think about targeted protection, sort of for key jurisdictions and key brands. Maybe there are some things that your clients can let go, and sometimes it's challenging to help educate them around that, but that can be some of the best strategy as companies like Starbucks or M&M's or Red Bull or Netflix have seen. Domain names too, of course, where there's a rogue website with an infringing name, really utilizing the UDRP is a great way to help take care of that quickly. Design patents are increasing as well with regard to non-functional and ornamental aspects of design rights, and then copyright too is something not to forget about that can be relative to a brand as well. Architecture and technological tools wise. Think about how PR can perhaps incentivize your strategy. That was a good move for Old Ox and Red Bull. It was a great move for Netflix. Blockchain and presents some opportunities for authentication that can be important and useful as we go forward. Certification programs, authentication technology, supply chain, track and trace mechanisms, consumer engagement, all of these are ways. One of the things that we can think, and Daniel and I were talking about this a little while this morning, is that in some ways, when it comes to trademark infringement and brand protection, you're not always going to file a lawsuit. There's, sort of hope for an injunction, and everyone's going to sink a bunch of costs into it. One of the things that we're really going to need to think about increasingly are using technology to be able to kind of help get rid of some of this stuff before it reaches that level. And so there are ways to design technological tools and architecture, so be on the lookout for that. The final toolkit I'll suggest is don't forget about ways to collaborate. Increasingly, through organizations like INTA, there are industry-focused groups that can really play a key role in helping governments better understand the practical implications of policy and practice, and can help troubleshoot and problem solve among one another. Police, prosecutors, and judges on the enforcement side, the counterfeiting side, legislators, investigators, and professional organizations. I mentioned INTA, but organizations like ASIPI can be incredibly helpful to facilitate collaboration between brands and other stakeholders, not just in industry, but cross-disciplinarily. So I think that covers it for me. I know we're going to get to questions, and I can't wait to learn from Daniel next. Thank you so much. Are you going to...
Gracias, Megan, por la presentación. Creo que las redes sociales, tal como las conocemos ahora, probablemente en 3 o 4 años.
As we know things now will probably be very different in a few years. Users are more demanding, and as you've said, there are challenges and opportunities for all companies that manage brands. It is what Megan mentioned is very important. And just in the copy in Peru, there's a guide for influencers to see how they handle publicity, which is so used, and as she mentioned, it's used in social networks. And so I think the talk we have, as I mentioned in the beginning, we can't just look at it from a professional perspective, but from a personal perspective as well. Social networks are part of our day-to-day work, the day-to-day of our companies. Now I would like to invite our next panelist, Daniel Legaspi, Associate of Intellectual Property of Santamarina and Steta. over 15 years of professional experience providing advisory on subjects of intellectual property, franchises, licenses, and technological aspects. Daniel obtained his license in law from the Universidad Iberoamericana. So, new technologies from the Pan American University. His practice is focused on helping clients to maximize the profitability of intangible assets through the development of an execution of strategies implying technology at a national and international level. In addition, he leads the work group for technology of the firm, focusing on assisting companies in digital environments that are beginning to explore Web 3.0 and the metaverse. He's been a speaker on subjects of intellectual property, on seminars from different associations, universities, and chambers of commerce, both local and international. He's a representative of the Presidency for the Protection of Intellectual Property and member of the Executive Committee of the National Chamber of Commerce, Services, and Tourism in Mexico. In 140 years of its existence, it's the first time that intellectual property has been considered fundamental to the lives of businesses. Without further ado, we'll hear from Daniel. Good afternoon. Thank you to the committee and for the invitation to share some of the ideas that we tend to work on in the dispatch to help clients to maximize their protection and defense of their intangible assets, and in this particular case of just brands around social networks. I would like for you to understand a little bit further what a social network actually is. We might just talk about a website right now, or something that involves social interaction, where we see an exchange of personal information and content with an objective of creating community among friends and interacting. I like this definition, at least from the Oxford Dictionary, because when you read this definition, you might see a little bit of the metaverse present in it. And so we have to start thinking about whether the metaverse today is the metaverse that we all are envisioning, or if it's just another social network. Is it just another platform? Right now, I don't know what will happen in 20 years, but right now I think it's just another social network.
De acuerdo a Hotsuit,
According to Hotsuit, these are the most used social networks in the world. As you can see, Facebook is at the top, YouTube, Instagram, and a few others, but this gives us an idea of what the jurisdictions of future conflicts will be. What are the most important brands where users, Megan has already described a lot of them, Generation Z, and maybe some millennials, I think we still have some presence, where those places will be. What are those jurisdictions? And the possible defense mechanisms that they've already been applying for some time. And start with a base of identification of these social networks. In that same report, there's mention that in 2021, at least in marketing, $154 billion were spent. And of those 154, we have 23 more than in previous years. This gives us an idea of the use of publicity on social networks, the exchange of information, and the trends we see in these kinds of platforms, and how what we call the buyer persona is changing. And this gives us an idea of what we have to protect our brands from. I won't go into too much into subjects of intellectual property, because this could take longer. but it's practically, this is what we have to identify in the social networks.
Hay productos o servicios de las redes sociales
There are products or services in social networks that are born within the social network or which have arrived there to capture more market. And so this is, I guess, where we have to start to thread from and analyze what the elements of protection are, where we'll have to focus mainly, in this case, to determine if they're traditional brands, non-traditional brands, if there will be a sort of, or if there are characteristics that might help identify a consumer or a seller, and to know if what we're going to do is sell products or services. And in this case, what will be the products or services that connect or relate. I was talking to a friend about the metaverse and how products arrive there or enter there. A company that is just a fashion company, how do you turn that fashion into something that can be applied to your avatar, for example, on this social network where you will be sharing this kind of information? There will be a challenge for authorities to start to consider classes that weren't intrinsically related, like as an additional target of protection. And so now we consider NFTs in class 9. And so there's some sort of guidelines for the brand in terms of what we have to start to register and how. And in marketing, it's important to have this direct communication between our legal areas and marketing in order to understand the growth plans, the territory, the target audience, and what type of influencers or what type of promotion we want to apply, so that all of this together might allow us to establish strategies for protection through the main actions of having the right registries in the right countries, keeping into account a first right basis and territorial law, the things that will give us the necessary steps to differentiate from users who try to connect their companies with our brands and others who might want to use with these brands without authorization. I think it's important to identify main accounts and satellite accounts within the same platforms. It's normal for these brands of, for example, pyramid schemes to keep subscriptions with their sellers, supposed, and then the sellers start to create their own accounts where they might sell the products or services. In this case, in practice, we have focused on creating these satellite accounts and establishing licenses for these vendors, such as catalogs for using the same photographs and the access to databases where the consumers, and in this case sellers of the brand, will use that kind of intellectual property to prevent infractions, to have better control over information as it circulates in social networks. The challenge, the only and main challenge anyway, is keeping these accounts active so that we can credit uses in classes that sometimes we hadn't even considered protecting, reading terms and conditions carefully. The first slide, as you might remember, the first 4 platforms derive from companies that are based in the US and adapt to the DMCA, and it's a point of reference for those new platforms. but still that doesn't make us exempt from staying updated and being clear on intellectual property and how we will establish new measures for brand protection. One of the challenges as well will be the creation of online profiles, and here with web archives, how we can find and use information, see what changes are taking place on sites, and active monitoring through artificial intelligence or other tools that may allow us to identify when there's an invasion or a creation of an additional account that has to do with our clients' brands. The subject here, or the challenge, is since these platforms don't follow the same principles of the creation of a brand, that they're not going to analyze if the brand is similar or not, that there's a challenge there, because from a legal perspective, we may be well based, but for the eyes of a trademark report, when we consider there's an inadequate use of a brand, it may not be enough. So we have to be careful about the language that's used to show a person that we don't know if they're a lawyer. We can determine whether or not there are rights being violated and apply that principle of territory, because what we consider an important or a famous brand in our country may or may not be important in other places. And if we apply the criteria of the UMPI from, I think, 15 years ago, which is it's a brand with the same service or product that's in the same language, to be purchased in the same coin as or currency of the country, and offers application of the laws of that country, that then the people behind these kinds of revisions, or the AI that is configured, has to be able to see how those rights are being impacted. And an important point that I like to talk about is awareness, not at a legal level, but at a corporate level. Everyone's responsibility in a company is to have some basic knowledge on intellectual property, and this will guarantee adequate protection and use of all of these kinds of brands and a better valuation of assets eventually. And at the time of when we establish this awareness, for a person who works in marketing, or a person who's working on sales, and sales even on virtual community managers, if they're aware, we can have better protection. So as many of you may know, we have these two types of mechanisms, the extrajudicial and judicial, depending on the country where we want to activate these types of defenses. In Mexico, for example, we have administrative infraction, the possibility to begin procedures for damages, and cautionary measures as well. And depending on the social network, we work through the trademark or reports, always being careful of our redaction. The most important challenge here as a company is to know if it is convenient for us to get ahead and use economic resources to begin a legal procedure, what we want to achieve. If we want to conclude the promotion of a product or account, do we want to terminate it, or do we want to begin a procedure because the company sees a possibility and an attractive economic opportunity to begin a procedure involving all of our participation, and we as colleagues for this, and so we never have to reach these kinds of situations. One of the things that I always like to mention is that we must understand that globalization has been here for a long time. We have to think beyond our countries. We have to get ahead of things and think about the type of industry that our clients face so that we understand the scope that each of the platforms wants to have, if we should be using LinkedIn, TikTok, Instagram, Facebook, or YouTube. And so the target is important. The buyer persona, having marketing knowledge will be important in this type of analysis for protection, and to always be a step ahead. Looking ahead will allow us to establish better defense situations, not protection. Since you're already getting ahead, we have to change the chip of our clients, because these aren't strategies for protection, they're strategies for investment. They're investments for intangible assets. And when you invest well, and this happens in practice, if I invest correctly my economic resources, then I'll benefit from this and I won't have to worry about other things. And so this time analysis, how long will a legal procedure take versus how long it would take to take down a site on a social network. When we keep this in mind, we will come up with better strategies for protection of social network presence. And our last point is, again, the evolving scenario. This is what in 2022 we have considered. Now, we don't know, and Megan has said it a little bit, the laws haven't completely been adapted to digital environments yet, and the trend is, or the tendency is that the way that our clients are reaching their consumers will change continuously. Instagram used to be very photo-based, and now they're all reels. Now we have the possibility to promote our brands on the different metaverses, Decentraland, Roblox, Second Life, or any other. And so we must stay up to date on what's happening on social networks and notice changes and adapt to the different terms and conditions of each of these networks. Thank you.
Gracias, Daniel.
Thank you, Daniel. Of the two brilliant presentations that we've had, social networks are in constant evolution. Social networks that we have today will not necessarily be the same in the next few years, and the content will be completely different. So I think with the subjects that we've talked about, this could lead to much more, but we have an introduction here and a summary of how this evolution has been taking place and how the brands must also evolve. We have a couple of minutes for some questions.
Hi, my question is for Megan.
Mi pregunta es para Megan. Los dueños de marcas, ¿cómo están?
Trademarks.
I think we're seeing a couple of different paths. Frankly, I think, the sort of more conventional path where brands will approach influencers directly with a C&D. But one of the things I think is particularly notable is that we're seeing an increasing number of brands that are not doing that, and they're letting it go because the influencers or the people who people are hoping to be influencers are presenting the brands in a positive way, and there's a certain calculus of if they send a cease and desist letter, if they want them to take down the content, there will be less sort of positive content out there. And also they risk, I think brands are increasingly afraid of the PR component. The PR component is huge right now. And a brand doesn't want to have a cease and desist letter go viral. So we're also seeing, just an offshoot of your question, is I think we're seeing many more varieties of cease and desist letters that are not so form-based, but are trying to kind of elicit that, are written very much with the knowledge that this is going to be posted, everywhere.
So they're afraid of this bad publicity and they just let it go, right?
I think there are a couple, some do not, but but I think that it's not only because of perhaps a fear of bad publicity, but I think part of it is these are the kind of things that a brand would want to put in the suitcase. This is positive. It's almost like, it's blurring the lines in some ways between, a positive Yelp review, a positive TripAdvisor review. There's sort of positive reviews out there. The difference is that the influencers are wanting to be perceived as affiliated with the brand, which makes it sort of rise to the level of something that we would classically think of as infringement. But the way that brands, I think, are increasingly looking at it is, that's, even if there's a likelihood of confusion of affiliation or sponsorship, no harm, no foul, let some of these things go. And on the contrary, you may also see brands that don't want to let it go, but you have to think about what's in the best interest of your client ultimately. Just because you can send a cease and desist letter, does that really mean that they should in every instance?
Yeah, but only if the products or the goods that they are promoting are not counterfeit, right?
Yes, I think counterfeit's a whole separate, that would be a whole...
like a big no-no, and they wouldn't let it go, right?
Yeah.
Okay, thank you.
Absolutely. Thanks for your question. Safety concerns, so it's not just, one of the things we've seen in the last couple of years in counterfeit goods, there's an explosion of counterfeit goods in not just healthcare, but toiletries, beauty products, electronics, things that can cause real safety concerns for brands and consumers.
Como posibilidad, derechos de autor.
I'm sorry, the microphone wasn't working, so what can we do? Can we copy a warning, or how can we play with that could be instead of saying cause? I don't know if we're talking about Creative Commons, for example. No. I want you to establish the difference in the term. This picture could, that's a possibility. And the difference with this copy causes. Can you please explain that almost subtlety, but in law, those differences can be severe. It's intrinsic. For example, could this type of license that is given towards the end, we could say that it's that in the license, when they don't talk about what you could exploit, it could be a very broad license. Necessarily, you could use it, and you might use it. I wouldn't dare to say that even for economical ends, but when you talk about cause, it will depend. The elaboration would be to the cause of what? The use of this picture or this image will cause a warning on behalf of its owner. Would you be warned at that moment? Understanding that you're not authorized to use this image for any kind of benefit. You will have to embrace yourself in the exceptions in terms of copyrights if you fulfill certain requisites in a determined country. I believe that over here, the topic is to analyze. I'm from the idea that the cause could take us to a negative situation, and the can or may goes more to a positive outcome. But towards the end, it will really depend. For example, taking into account a case from 7 years ago, a friend of mine, a photographer, uploaded some pictures to a catalog, and a renowned company, Converse, thought that they could use the picture, and we're talking about 7 years ago. Artificial intelligence that he had hired told him 10 minutes later of that post that was already in social media, and unfortunately he didn't want to start any kind of actions because it was an image that was mutilated. They had chopped out certain parts. So independently of the may or cause, the premise is that you cannot use it. You need to ask for authorization, for a permit, because towards the end, Well, unless I use it for a personal end, let's say that most of the time towards the end there is an interest in terms of an income that you could gain from these kind of images. I don't know if that would answer your question. I apologize, but he's not using the microphone. And what is commercial? No, and I'm not saying it ironically. What is commercial? Because the justification is that towards the end you're not using it commercially, but towards the end, thanks to the presentation or the usage, you increase, for example, your sales, and indirectly I obtain another benefit. So there's always an indirect gain. So you must always use or obtain a permission. You cannot read the may or the can from a broad perspective of a license. Okay, last question. Good afternoon. My question is, well, for the companies to be updated in social media, we need to create content in social media, and this creation of content in social media is sometimes done in public spaces. And in public spaces, we have, as the background of a screen, graffitis, murals, or art plays that could be in the public domain. Now, the authors of these graffitis and this artwork do not give an authorization because it's not an essential element of the content in social media. But how could we balance these rights, the right of being able to create content in the public road, and the right of the author of the graffiti or that mural or artwork?
Happy, what an interesting question. And it reminds me of a case that a partner that I worked with, she represented an artist that was one of those graffiti artists that ended up kind of in the background of content, and it was content for a music video. And in the music video, you can see, in the foreground, and this was, the singer, and then you see this graffiti, and unfortunately, the content really honed in on a section where the artist actually put their name and phone number on the artwork, so that it was incredibly easy to trace. But I think that there again is there's kind of this. I think we do have, and this is different region to region, country to country, but a different perception of fair use. And I think that's another area where I know we're talking brands today, but if we were talking about copyrights, I think that one of the things that we're seeing is a change in norms there as well. And as you think about some of the fair use factors, it's in a social media culture, in an Instagram culture, it's, everyone doesn't post social media as you're trying to get started and you're posting social media, you're not doing it in front of a green screen. We're living and breathing in a world often where these things are prone to happen. So in contrast to kind of the old days when there might be a music video with something that is a graffiti artist where it ends up being extremely clear, I think we are seeing an evolution in the norms there as well. And I don't know if Daniel is that would be his perception as well, or if he would sort of take a different approach.
No, yo creo que al final.
No, I believe that towards the end, it is an interesting question, because what prevails the most? The right to create and have this protection, where the street artist also has a certain protection, because towards the end, his work should be in a certain way. Well, he should receive some profit, in some sort of way. And I don't know if any of you went through this tour of the graffitis and murals that we have here, but thinking from that aspect, there's people that live from this tour and this usage of these exploitation of works of artwork that are done in a public road or in a public way. I could go a bit back And really, we would have to study who has the heritage kind of right to these public works. And from there, we could determine if the usage of these kind of works for an advertising purpose, well, would take us back to the same topic. It's a matter of profit, where you would need to require an authorization. And I really believe that it's an interesting question. I understand the justification of those companies that need how to live, but we all need a way or a mean of living, but not because you need to live or breathe, you can do whatever you want. I believe that there are specific rules where you must require authorization, and it's not just because of the purpose of earning money. I believe it's just to follow some steps to avoid problems. Okay, so we'll start with this interesting question and different solutions and alternatives that could give us a new space for a new panel with the topic of wall painting and urban artists. I want to thank Megan and Daniel for their presentations, and we want to invite you to continue participating. This is the last panel, and thank you very much for attending to this conference. Thank you very much.
Les